By this point, we have established the theoretical basis for a balance bench, explored its practical manifestations in various jurisdictions, and considered how legal systems might implement such a model. Yet, no blueprint for reform can avoid obstacles altogether. Critics raise fundamental questions. Will granting judges extra powers skew outcomes? Could resource disparities persist or even worsen? And might political forces intrude on what is meant to be a neutral, truth-seeking process? These concerns are neither trivial nor easily dismissed. They point to the delicate task of creating a system that balances judicial initiative with robust safeguards against bias or overreach. In this chapter, we turn a critical eye to the balanced bench concept. First, we examine the core arguments advanced by skeptics, from worries about judicial activism to fears of eroding the rights of the accused or underrepresented parties. Next, we explore structural and cultural factors that could derail or dilute the effectiveness of hybrid legal processes. We then address the broader question of public trust. A balance bench that fails to gain legitimacy in the public's eyes risks becoming a procedural experiment with little real-world impact. Finally, we propose ways to navigate these headwinds and outline how ongoing evaluation can safeguard the integrity of a balance bench. By grappling head-on with the critiques and challenges, we hope to illuminate a feasible path forward for achieving the reforms articulated in earlier chapters. Core critiques of the balance bench. Although the balance bench draws from the strengths of adversarial and inquisitorial traditions, it necessarily departs from each model's pure form. This departure sparks a range of critiques. Judicial overreach. Some adversarial purists argue that endowing judges with investigative powers undermines the principle of party autonomy. They worry that a more proactive judiciary could usurp the role of the defense or prosecution, tipping the scales of justice, even inadvertently. Critics point out that if a judge initiates an extensive line of questioning, calls additional witnesses, or commissions expert reports, the judge might end up shaping the narrative that emerges at trial. Potential bias. In inquisitorial systems, the judge is presumed capable of impartial investigation. Yet, research shows that even well-intentioned judges can experience confirmation bias once they form a working hypothesis. By granting judges a deeper role in uncovering evidence, there is a risk that their early impressions could steer the entire case. Critics question whether safeguards, such as transparency requirements or multi-judge panels, adequately counteract this possibility. Resource inequality. Hybrid systems often strive to mitigate resource disparities by letting judges request evidence that parties might not have the means or knowledge to obtain. Still, detractors contend that well-financed parties can continue to dominate through procedural maneuvers, superior legal counsel, and advanced investigatory techniques. If states fail to provide robust legal aid, the balanced bench might unintentionally entrench existing inequities rather than dissolve them. Cultural resistance. Legal practitioners who have built their professional identities on the adversarial or inquisitorial approach often resist change. Attorneys accustomed to adversarial battle or judges trained to maintain a hands-off stance might view hybrid procedures as meddling or unwieldy. Meanwhile, inquisitorial judges who have historically commanded broad investigatory powers might resist, ceding some control to litigants in an adversarial-style cross-examination. Skeptics argue that such entrenched cultural norms could stall or dilute the efficacy of any hybrid reform. Complexity and cost. Transitioning to a balanced bench can demand expensive infrastructure, new technology, and extensive judicial training. Furthermore, managing a system where both judges and parties undertake investigation can add layers of procedural intricacy. Critics claim this complexity could lead to longer case durations and ballooning costs, exactly the problems hybrid systems often promise to remedy. Each critique underscores the high stakes of reconfiguring foundational judicial processes. Addressing these issues transparently is critical not just for the success of any reform, but also for maintaining public trust in the judiciary's core mission of delivering justice. Judicial activism vs judicial neutrality. One of the most prominent concerns about the balance bench is the perceived risk of judicial activism or overreach. Traditionally, in adversarial systems, judges remain neutral referees. Critics worry that, once empowered to direct investigations, these same judges could begin to drive cases in ways that jeopardize fairness. A core question therefore emerges. How can judges be both active truth seekers and strictly impartial? The balanced bench model responds with structural and procedural safeguards. For instance, rules might require judges to disclose any evidence-gathering actions in open court, granting both parties a chance to object. If the judge requests an expert opinion, the choice of expert could be subjected to a transparent appointment process, such as a neutral list of accredited professionals or a randomized selection. Similarly, judicial councils or review panels could periodically assess whether a judge's investigatory conduct shows bias or favoritism. Yet, no set of procedural rules can fully eliminate the human propensity toward confirmation bias. Research in cognitive science demonstrates that once people form a preliminary conclusion, they tend to seek information that reinforces it. Judicial training can mitigate this effect to some extent, teaching judges to remain open to contradictory evidence. But the challenge remains. As soon as judges wade into the fact-finding arena, they risk becoming attached to particular lines of reasoning. Thus, critics urge that a truly balanced bench should also maintain a distinct adjudicatory phase overseen by judges or panels that have not been heavily involved in the investigative stage. This structural separation might be the strongest buffer against undue judicial influence. Entrenched inequalities and resource constraints. One of the balanced bench's promises is a more level playing field, especially where resource imbalances between parties are stark. In an ideal scenario, if a disadvantaged party lacks funds to hire an expert witness, the judge could order and fund an independent expert evaluation, ensuring critical evidence is not lost. Similarly, judges could direct the disclosure of vital documents that a powerful party might otherwise conceal. However, this remedy rests on adequate state funding for courts, legal aid, and support services. In many jurisdictions, courts are already under-resourced, facing backlogs and limited budgets. Critics question whether governments will allocate the substantial resources necessary to run a balanced bench effectively. If not, wealthier litigants may continue to exploit their advantages, and the judge's broader powers might do little more than paper over systemic inequalities. Moreover, critics point out that well-funded parties could actually harness the balanced bench to their benefit, using the judge's investigatory capabilities as yet another tool for discovery. If repeated judicial inquiries flood the docket with voluminous data, resource-strapped opponents might lack the capacity to analyze and respond effectively. In this scenario, the balanced bench risks becoming an inadvertent ally of deep-pocketed litigants, unless robust procedural controls and equitable funding measures are put in place. Cultural and institutional barriers. Shifting to a balanced bench also involves a fundamental cultural transformation. In adversarial systems, attorneys often pride themselves on winning through strategic ingenuity. In inquisitorial systems, judges may take pride in conducting meticulous investigations. A hybrid approach asks these players to rethink their roles. For lawyers, the balanced bench can feel disorienting, as judges assume a more assertive role. Defense attorneys might fear that a proactive judge could usurp their duty to challenge the prosecution's case. Conversely, prosecutors might see the judge's interventions as either unnecessary meddling or an unwelcome check on their discretion. Unless carefully managed, these attitudes can morph into bureaucratic sabotage, with attorneys pushing back against judicial involvement at every step. Judges themselves may resist relinquishing aspects of their traditional function. In inquisitorial settings, a judge accustomed to leading the inquiry may chafe at the concept of giving adversarial counsel free rein in cross-examination. Alternatively, in adversarial settings, a judge trained to intervene only when the rules of evidence are broken may be reluctant to adopt an investigatory stance. Overcoming these cultural barriers requires sustained engagement, educational programs, and strong leadership from judicial councils or bar associations that champion the balanced bench. Without broad-based buy-in, Even carefully designed reforms may fail to take root. Fears of politicization. Another critique arises from the potential politicization of the judiciary. Critics worry that once judges wield more direct investigative powers, they become more susceptible to external pressures, whether from government officials, political parties, or powerful interest groups. In some adversarial systems, the principle of party-driven trials serves as a buffer against political interference. The judge's role is so limited that pressuring them rarely yields significant influence. In certain inquisitorial models, strong judicial independence protections exist, but critics argue that a single judge with sweeping powers could become a potent target for manipulation. To counteract these risks, proponents of the balanced bench emphasize institutional design. Mechanisms like multiple judge panels, randomized assignment of cases, and transparent publication of judicial decisions can deter politically motivated meddling. A well-funded judicial oversight body, insulated from partisan influence, can also help. Such a body could investigate allegations of bias or misconduct, sanctioning judges who break ethical rules. Still, the ultimate efficacy of these measures depends on the broader political culture. Where rule of law is weak or corruption is endemic, strengthening a judge's investigative capacity could indeed make them more vulnerable. Thus, the balanced bench presupposes a legal environment that respects judicial independence, a condition that cannot be taken for granted in every jurisdiction. Public trust and perception. No judicial reform can succeed if it loses the confidence of the public. The balanced bench concept, while principled, can initially seem opaque or convoluted to laypersons unfamiliar with legal intricacies. Skeptics might label it a top-down experiment that benefits lawyers and judges, not ordinary citizens. Conversely, where scandal or discontent with the existing system has eroded trust, reforms perceived as insufficient or confusing might further alienate the public. Thus, transparency in communicating how the balanced bench works is imperative. Courts and policymakers should proactively share clear, accessible explanations of new procedures, highlighting safeguards that protect rights and the ways in which an active judicial role can uncover hidden evidence. Public outreach, through community meetings, partnerships with civil society groups, and educational campaigns, helps demystify the concept. Allowing media access to key proceedings can also enhance understanding, though it must be balanced against privacy concerns. Early, tangible successes build public trust more than abstract theory. For instance, if a balanced bench approach quickly resolves a high-profile case in which a vulnerable defendant's rights might otherwise have been overlooked, that outcome can serve as a powerful endorsement. However, if mistakes or controversies arise, such as a judge appearing biased or investigations dragging on interminably, public skepticism could swiftly escalate. The margin for error in a nascent hybrid system is, therefore, slim. Managing complexity and avoiding procedural overload. A common concern is that combining the thoroughness of an inquisitorial process with the adversarial tradition's emphasis on cross-examination will create a procedural chimera, a bloated system weighed down by overlapping tasks. Critics point to potential pitfalls. Lengthy pretrial investigations. Judges might be compelled to order multiple rounds of expert assessments, witness interviews, or document requests. Parties could then exploit or challenge these interventions, leading to an almost endless pretrial phase. Complex trials. If judges and attorneys are both actively questioning witnesses, the courtroom could become a battleground of competing inquiries, confusing jurors and elongating proceedings. Duplicative efforts. The balanced bench might require more court staff, more hearings, and more oversight to coordinate the interplay of investigative and adversarial roles, thereby inflating costs. Addressing these concerns involves designing lean procedural rules that delineate clear phases for judicial and party-driven inquiries, coupled with strict timelines. For instance, a judge might open limited windows for additional investigative steps, requiring a demonstrable reason before expanding them. Similarly, trials can be structured in segments, one for judge-led questioning, one for adversarial cross-examination, to avoid confusion. Properly implemented, these features can mitigate overload and even expedite cases by minimizing the strategic stalling, that often plagues purely adversarial systems. Measuring outcomes and ongoing evaluation. The balanced bench should not be treated as a static reform, but as an evolving framework that requires continuous assessment. Measuring outcomes is crucial to address criticisms and verify that the model delivers on its promises. Metrics might include case resolution times. Do hybrid procedures speed up or slow down the administration of justice? Error rates and appeals. Are wrongful convictions or miscarriages of justice reduced under a balance bench? And how often are appellate courts reversing decisions based on procedural error or perceived bias? Public satisfaction. Periodic surveys and qualitative interviews with litigants, witnesses, and the wider public can gauge whether people feel the system is fair, transparent, and trustworthy. Resource utilization. Is the court system more or less expensive to operate? Do investments in technology and training offset potential gains in efficiency? Such metrics should be reviewed by independent bodies, whether academic institutions, judicial councils, or non-governmental organizations. Their findings can drive targeted reforms, adjusting rules, reallocating resources, or refining training programs. A feedback loop that continuously refines the balanced bench model acknowledges that no single blueprint, no matter how carefully drafted, will be perfect from the outset. Strategies for overcoming critiques. Despite the formidable nature of these critiques, many can be addressed through strategic foresight, inclusive policymaking, and methodical implementation. Key strategies include phased implementation and pilot programs. Rather than leaping wholesale into a national hybrid model, jurisdictions can experiment with pilot courts. This allows for real-time testing of rules and an opportunity to correct issues before widespread adoption. Robust oversight mechanisms. Creating or strengthening judicial councils, ethics boards, and appellate structures can ensure judges exercise their enhanced powers responsibly. Transparent oversight fosters accountability and nurtures public confidence. Emphasis on training and professional development. Continuous education for judges, attorneys, and court personnel reduces cultural inertia and clarifies new procedural norms. Rather than a one-time workshop, ongoing training helps embed balanced bench principles into daily practice. Public engagement and communication. Courts should regularly communicate how and why hybrid procedures are being used, spotlighting success stories and explaining procedural safeguards. Open dialogue reduces confusion and garners community support. Equitable funding models. To avoid entrenching inequalities, states must commit to robust legal aid programs and adequate court funding. Judges cannot fulfill a proactive role effectively if budget constraints impede their ability to order expert analyses or additional evidence collection. When these strategies are pursued collectively, the balanced bench stands a far better chance of gaining traction and delivering on its promises. Carefully executed reforms, coupled with consistent reevaluation and refinement, can transform critiques from insurmountable obstacles into actionable catalysts for improvement. Every major legal reform encounters robust debate and pointed criticism. The balanced bench is no exception. Indeed, its very essence, fusing adversarial and inquisitorial elements, means it challenges entrenched notions of how courts ought to function. Skeptics are right to question whether an expanded judicial role invites bias, politicization, or new inefficiencies. They are equally correct to worry that hybrid procedures might inadvertently preserve or even exacerbate resource disparities. Yet the persistence of these questions should not paralyze reform. As earlier chapters demonstrated, many jurisdictions that have ventured into hybrid territory report tangible gains in procedural fairness, efficiency, and public confidence. These examples show that thoughtful design, systematic safeguards, and strong institutional support can enable courts to transcend the binaries that have long dominated legal discourse. Rather than seeking a perfect equilibrium that addresses every critique from the outset, advocates of the balanced bench should embrace a mindset of continuous improvement. Early pilot programs can identify stumbling blocks, transparent oversight can deter abuses, and open lines of communication can secure the public's trust. Over time, a hybrid model that is flexible, well-resourced, and ethically grounded can fulfill its promise. a judiciary that combines the best of adversarial rigor and inquisitorial thoroughness to deliver justice more effectively. In the next chapter, we take these reflections a step further, exploring the interplay between broader social change and legal reforms, and envisioning how a balanced bench might evolve in parallel with societal shifts. If the ultimate goal is to uphold justice in a complex and rapidly changing world, then acknowledging and addressing the challenges head-on is a necessary step toward building a system that fosters both legitimacy and fairness.